Welcome to Audit the Audit, where we sort out the who and what and the right and wrong of police interactions. This episode covers the Americans with Disabilities Act, trespassing, and concealing identity, and is brought to us by Cop Watch's channel. Be sure to check out the description below and give them the credit that they deserve. On August 19th, 2022, officers Kenneth Skeens, Marcos Flores, and Gregory Radigan of the Albuquerque Police Department responded to a Target location in Albuquerque, New Mexico upon reports of shoplifters in the store. According to Officer Skeens, a Target loss prevention employee then informed him of another quote-unquote shoplifter, seemingly referring to Matthew McManus, a 53-year-old man with unidentified disabilities who was struggling to complete a purchase at a self-checkout kiosk. Although there seems to be some dispute as to whether the Target employee claimed Mr. McManus was a shoplifter or wanted him to be removed from the store, the Albuquerque officers approached Mr. McManus at the self-checkout. The interaction that followed was captured on body camera.
Gotcha, you take two. Hi, sir, go ahead and take your money. Go ahead and grab all your money. Let's walk out, okay? Take your money out. Do you want to walk us to walk you out, or you want to walk us out? Go ahead and put your money in there. I'm going to move this back, okay? You're coming with us, okay? You gotta go. Gotcha. Take your money out. You're coming with us now, okay? So go ahead and grab your money, sir. We'll be walking out, okay? Go ahead and take your money out. So we're going to take your money out for you. Do you want to walk us to walk you out, or you're leaving, okay? You're going to be issued a criminal trespasses so you can't come back to the city anymore, okay?
I was just getting my money out.
So go ahead and grab your money, sir. Here's your money. Put it in your pouch. Walk down, okay? And you're going to be identified, okay? And you're going to be issued a criminal trespasses. That's okay. Come back and walk down, okay?
I'm calling 911.
The officers tell Mr. McManus that he is being criminally trespassed from the store because he quote-unquote took too long to make his purchase. Although it is unclear whether Target asked that Mr. McManus be removed from the store, if a Target employee actually did request that the officers trespass him, this action potentially violated Title III of the Americans with Disabilities Act. Title III of the ADA applies to places of public accommodation, which Section 12-181 of Title 42 of the United States Code defines as including bakeries, grocery stores, clothing stores, hardware stores, shopping centers, and other sales and rental establishments. Under Section 12-182 of Title 42 of the United States Code, which is part of Title III, quote, "No individual shall be discriminated against on the basis of disability in the full and equal enjoyment of the goods, services, facilities, privileges, advantages, or accommodations of any place of public accommodation by any person who owns, leases, or operates a place of public accommodation." The statute also states that, quote, "Discrimination includes a failure to make reasonable modifications in policies, practices, or procedures when such modifications are necessary to afford such goods, services, facilities, privileges, advantages, or accommodations to individuals with disabilities, and also includes," now quoting again, "a failure to take such steps as may be necessary to ensure that no individual with a disability is excluded, denied services, segregated, or otherwise treated differently than other individuals because of the absence of auxiliary aids and services." Here, it seems obvious the Target could have easily accommodated Mr. McManus's disability by an employee offering assistance or moving him to a cashier checkout, or by the store simply allowing him the additional time he needed to complete the purchase on his own. It is also possible that a court would find that the Albuquerque officers were required to provide reasonable accommodation to Mr. McManus, although the case law surrounding the issue is complicated and conflicted. Now, while Title III of the ADA applies to private entities operating places of public accommodation, Title II covers public entities. According to Section 12-132 of Title 42 of the U.S. Code, quote, "No qualified individual with a disability shall, by reason of such disability, be excluded from participation in or be denied the benefits of the services, programs, or activities of a public entity, or be subjected to discrimination by any such entity." In interpreting this statute, courts have consistently held that police departments are public entities under Title II, and concluded that at least some law enforcement activities are considered services, programs, or activities for the purposes of the ADA. On the other hand, as the Congressional Research Service noted in its publication The Americans with Disabilities Act and On-the-Street Police Encounters, quote, "While courts agree that Title II applies to at least some law enforcement functions, they disagree on whether the ADA applies to on-the-street police encounters, such as use of force or arrests." Unfortunately, we do not have time to explore the nuances of these complex legal issues in a single ATA episode, but I have included a link to the Congressional Research Service's publication in the description down below, and I would encourage you to check it out if you're interested in learning more on this topic.
I was just getting money I got. I don't want to lose it. Hey, what? I'm sorry, no, I sit you next to I ain't hitting anyone. You're talking to me.
Alright, you got an ID on you, man?
Not giving you any idea.
If you don't identify yourself, you're under arrest, okay?
You're not police.
Yes, we are. We're out here keeping
No, you're not. You're security.
So what's your name, man?
None of your business.
Alright, then you're under arrest. Go ahead, put your hands behind your back. Refusing to identify yourself, correct?
Who you calling, man? You ain't even
He's
press
calling
call
911. That's what he said anyway. So yeah, just go ahead and put him in handcuffs, because he's refusing to identify himself.
Okay, hold on.
I was just paying. I was just had my stuff locked in my fanny pack. And the security guards came, and I didn't take more time than anyone else. The other ones before me.
So now you're going to be charged, okay, with concealing identity, resisting officers, okay?
No,
And you're going to be trespassed, so you can never come back here again, okay?
Officer Skeens informs Mr. McManus that he's going to be charged with concealing identity and resisting officers, and that he's being trespassed from the Target store so he can never come back. We will discuss the concealing identity and resisting charges later in this episode, but for now, viewers should note that under Section 30-14-1 of the New Mexico statutes, quote, criminal trespass consists of knowingly entering or remaining upon the unposted lands of another, knowing that such consent to enter or remain is denied or withdrawn by the owner or occupant thereof. As the Court of Appeals of New Mexico explained in the 2002 case of State versus Tower, which was overruled on other grounds in 2014, although shoppers are given authority to enter a store that is open to the public as a place of commerce, quote, there is no question that a private property owner can restrict the use of its property, either to certain persons or to those purposes for which it was dedicated, so long as the restrictions are not discriminatory. Therefore, although there are serious questions as to whether Mr. McManus's exclusion from the property was discriminatory, generally speaking, an individual can be arrested for trespassing in a public store if they enter or refuse to leave after being told that their permission to be in the store has been revoked. However, the statute explicitly states that consent to remain must be withdrawn by the owner or occupant of the property, and Officer Skeens certainly did not have the authority to unilaterally revoke Mr. McManus's invitation to shop at the Target. Now, although there is some question as to whether Target wanted Mr. McManus to be trespassed from the property, it is clear that no employee from Target ever informed Mr. McManus that his permission to be in the store had been withdrawn. Further, according to the jury instructions for the New Mexico trespassing statute, in order to sustain a conviction, a prosecutor must prove that the defendant had, quote, actual subjective knowledge that permission to enter or remain had been withdrawn, rather than proof of what a reasonable person would have understood. Therefore, if Mr. McManus was charged with trespassing for refusing to leave the store, he could also argue that his disability prevented him from knowing and understanding that his permission to shop had been revoked.
Stand up.
No, that's not right. I was just paying my things. And I didn't know you were police officers.
Yes, we told you that already.
I didn't see your badge.
Okay, well, we told you, right?
We identified
Security
ourselves.
guards say they're police officers
We
all the
identified
time.
ourselves as Albuquerque Police.
Let's
We
go
had
ahead
a
and get
reason
him
to talk to you.
stood up and search.
The reason to talk to you was they didn't want you in there no more, okay? So we have the reason. We asked you your name. You didn't give us your name. That's
What was
concealed
the
identity.
reason?
They didn't want you there, and they have that right as the business not to want you there anymore. We're gonna help you stand up. We're gonna put you in that patrol unit over there, okay? Sound good?
No, it don't sound good.
Well, that's what's gonna happen.
911, help me, please.
No one's on the phone, man.
I didn't see their badge. I didn't know they're police officers.
Well, everything's on camera, just so you know. You became very resistant in the store, and out
No,
here.
I didn't.
We asked you your name. I'm done explaining to you. That's fine. You're under arrest.
You're under arrest, okay? That's not changing now.
For what?
Concealing identity, resisting officers, okay?
I didn't know you were police officers. How can
I told you.
conceal?
That's your own fault. You didn't listen, okay? I can't help you with that. You don't want to listen. But go
I
ahead, just
didn't
stand up.
believe you were police officers.
Stand up. You didn't believe us?
You
Doesn't
look
matter.
like security guards.
Go over here.
Despite the fact that Mr. McManus repeatedly explains that he thought the officers were security guards, Officer Skeens continues to insist that Mr. McManus will be charged with concealing identity and resisting officers. Section 30-22-1 of the New Mexico statutes, which codifies the offense of resisting, evading, or obstructing an officer, prohibits, now quoting, resisting or abusing any peace officer in the lawful discharge of his duties. Although physical resistance to an arrest or seizure can constitute a violation of this statute, according to the jury instructions for this statute, the state must prove beyond a reasonable doubt that the defendant knew that the individual they were resisting was a police officer. Accordingly, given Mr. McManus's repeated insistence that he did not know that the officers were law enforcement, he would have a defense to a resisting charge. Additionally, Mr. McManus could argue that he resisted the officers' attempts to physically remove him from the store because they were acting with excessive force. The Court of Appeals of New Mexico concluded in the 2015 case of State versus Jahidi that, quote, an officer is still acting within the lawful discharge of the officer's duties, even if conducting a search or seizure that violates an individual's constitutional rights because it is not supported by reasonable suspicion or probable cause. And therefore, that, now quoting again, if the individual physically resists the officer, the individual may be charged with and convicted of resisting, evading, or obstructing an officer. However, as the Supreme Court of New Mexico outlined in the 2008 case of State versus Ellis, a criminal defendant has a qualified right to assert a self-defense claim against a police officer when the officer is using excessive force. And while an individual does not have the right to self-defense when an officer is using necessary force to effect an arrest, they are permitted to defend themselves against excessive use of force by an officer. Consequently, if a court concluded that the officers were using excessive force against Mr. McManus, his non-violent physical resistance to their attempts to remove him could be found to be legally justified. Now, as to the concealing identity charge, under Section 30-22-3 of the New Mexico statutes, quote, concealing identity consists of concealing one's true name or identity or disguising oneself with intent to obstruct the due execution of the law or with intent to intimidate, hinder, or interrupt any public officer in a legal performance of his duty. In the 1999 case of State versus Dawson, the Court of Appeals of New Mexico determined that this statute, quote, requires a person to furnish identifying information immediately upon request, or if the person has reasonable concerns about the validity of the request, so soon thereafter as not to cause any substantial inconvenience or expense to the police. Even so, the Court of Appeals clarified in the 2021 case of State versus Aguilar that the concealing identity statute only applies when an officer has reasonable suspicion to detain the individual whose identity is requested, because, quote, absent evidence establishing reasonable suspicion, the seizure of a defendant for questioning is unlawful under the Fourth Amendment, and the state cannot prove that the officer was acting in the so-called legal performance of his duty. Unless the officer has reasonable suspicion to detain the suspect and question him about his identity, concealing one's identity is not a crime, and the individual is free to walk away. Now, in this situation, the Albuquerque officers will likely argue that they had suspicion to detain Mr. McManus based on his physical resistance to their efforts to trespass him from the target. However, as we discussed earlier in this episode, there are serious questions about the legality of his removal from the store, and Mr. McManus would certainly have a solid argument that the officers did not have reasonable suspicion to detain him given the potentially unlawful nature of their conduct up to this point.
Don't resist anymore. Stop.
Just walk, man.
No.
Just walk.
No. I didn't do nothing. I was just about to pay my money in the automated system. I was putting my money in and I didn't do nothing.
We told you what's going on. Stop.
I didn't
I'm
know
done
that.
with you.
You
Stop.
didn't explain it.
Separate your feet. We told you who we were.
I got security guards tell me they were police.
Well, then, sorry those security guards told you that, but they...
We are actual law enforcement officers. What's your name? Tell me your name. You gonna tell me anything, man?
Not till I get a lawyer.
Well, that sucks to suck, man.
No, I have the right to remain silent.
Not when it comes to your name.
No, that's...
You do, but that's why now you're going to jail for concealing identity.
So Matthew, here's what you're under arrest for, okay? Concealing identity and resisting, evading, obstructing officers, okay?
Don't catch a felony charge by hitting me or anything. Step in.
Just make it easy.
All I was doing was paying for my things.
Yeah, it was explained to you.
And you had to cut off one of my fanny packs. You know, you saw how hard it is to get my money out. And I was trying to get my money out, and I got it all out. And then you came and I thought you were a security guard.
After the arrest, Mr. McManus was taken to the hospital to be assessed for unidentified medical complaints. He was released and issued a criminal summons for charges of concealing identity and resisting, evading, or obstructing an officer. Court records show that the charges against Mr. McManus were dismissed on October 19, 2022, after he was found not to be competent to stand trial. On February 3, 2023, the Albuquerque Police Department fired Officer Skeens based on his actions against Mr. McManus, as the department concluded that there was no reason to arrest him, as well as his role in the shooting death of 27-year-old Keyshawn Thomas a little more than a week after the encounter featured in this episode, during which the APD found that Officer Skeens violated department policies. Notably, Officer Flores was also involved in Mr. Thomas's death, and in May of 2023, both officers were named in a wrongful death lawsuit. Former Officer Skeens' attorney, John D'Amato, has stated that he's appealing his termination from the APD. In support of the appeal, Mr. D'Amato claimed that Mr. McManus' arrest was the result of a misunderstanding between the officers and a target loss prevention associate that led the officers to believe that the store wanted Mr. McManus removed. As of the date of writing this episode, no updates on the status of this appeal have been publicly released. On July 13, 2023, New Mexico Attorney General Raul Torres announced that his office had filed criminal charges against Officer Skeens stemming from his, now quoting, unlawful arrest of Mr. McManus. Former Officer Skeens was charged with false imprisonment and battery for his conduct against Mr. McManus, and perjury and making a false report for allegedly making a false statement under oath related to the arrest and making a false report to other law enforcement staff. In a press release regarding the charges, Attorney General Torres stated that, quote, rather than acting as a professional public servant and a guardian of vulnerable members of this community, Mr. Skeens engaged in abusive and unlawful behavior that undermined public safety and violated his oath as a peace officer in the state of New Mexico. Attorney General Torres also argued that Mr. McManus, quote, clearly hadn't committed a crime, and that, now quoting again, in the absence of criminal activity, there was simply no justification for the officer to engage with him in the way that he did and to escalate the situation in the way that he did. The New Mexico Attorney General does not intend to pursue charges against Officers Flores and Radigan, as Officer Skeens was the one in control of the situation. Former Officer Skeens has pleaded not guilty to all 4 counts, and as of the date of writing this episode, the charges against him are still pending. Overall, the Albuquerque police officers get an F for physically removing a man with disabilities from a store for taking quote-unquote too long to complete a transaction, failing to exercise common sense and discretion by pursuing criminal charges against a man with clear mental limitations, and demonstrating an appalling lack of empathy throughout the encounter. Instead of simply offering to assist Mr. McManus or allowing him to take the time he needed to complete the transaction, the Albuquerque officers chose to forcibly remove him and arrest him without showing any concern or consideration for his disability, and repeatedly blamed him for his confusion about the situation. I applaud the Albuquerque Police Department for removing Officer Skeens, and the New Mexico Attorney General for pursuing criminal charges against him, although I do question the lack of action against Officers Flores and Radigan. Even if the officers had probable cause to arrest Mr. McManus, given his evident disability and the fact that he was clearly not a danger to anyone, choosing to arrest him for his actions against the officers demonstrated incredibly poor discretion and an overly inflated sense of ego that has no place in modern policing. As for Mr. McManus, I cannot rightfully assign a grade to an individual with disabilities who was treated so abhorrently by police officers who should have helped and protected him. The fact that Mr. McManus was found to be incompetent to stand trial speaks to the severity of his disability, and I know this situation must have been terrifying and immensely confusing for him. Even still, I commend Mr. McManus for attempting to assert his rights and protesting the officer's horrifying actions in a peaceful manner, and reaffirm that he in no way deserved to be treated like a criminal for simply trying to purchase a bike. Individuals with disabilities have unique perspectives and many remarkable qualities to offer society, and this encounter serves as a sad reminder of the ways they can be misunderstood, vilified, and excluded from participating in everyday activities. I hope that Mr. McManus has been able to heal from the trauma he suffered during this experience, and that he was able to purchase a bike from a more accommodating retailer. Let us know if there is an interaction or legal topic that you would like us to discuss in the comments below. Thank you for watching, and don't forget to check out my second channel for even more police interaction content.